Hello, everybody. This is David Bryson. Thank you for joining me today for our next video in this series on Juris, presenting yourself in court. This is going to be video number 3 on beginning a lawsuit. We're going to cover how to determine if you have a good case, what type of a court has the power to hear your case. We're going to be discussing jurisdiction and subject matter jurisdiction, the plaintiff's complaint, the summons, and the defendant's response. And let's go ahead and pull up a nice background for you. So yes, we are embarking on this series. We hope that you've already listened to video number 1 and 2, and there will be many more to follow. And we really believe that our greatest option right now to help reverse these trends towards lawlessness and abuse of power and dereliction of duty among our public servants and our government is for citizens to become informed and for people in general to become informed. There's even concern about the use of the term citizen as it applies to a 14th Amendment citizen, which puts you into kind of a very vulnerable legal category. So we believe in an informed populace, and that everybody should know the Constitution and the Declaration of Independence like the back of their hand, and that we should all be exercising our rights with utmost vigor in order to preserve rights for future generations. So let's go ahead and pull up our background screenshot here, and we will jump right into today's video. Okay, so today, video number 3. Almost nobody wants to go to court. People usually attempt to resolve disputes out of court informally before filing a lawsuit. For example, if someone owes you money from a contract, you will most likely ask the person for the money before suing. If your request is denied, you may try another phone call, a written request for payment called a demand letter, or perhaps a face-to-face negotiation session. Assuming enough money is at stake, your next step might be to show you mean business by hiring a lawyer to call or to write on your behalf. If you still haven't gotten paid, you might suggest a formal mediation or arbitration proceeding. You can check out video 1 or 6 for more of these out-of-court processes, called Alternative Dispute Resolution, or ADR. Eventually, however, if the person who owes you money continues to refuse to pay, you have to make a choice. You can either bring a lawsuit or write off the money. Caution here, can you sue? These days, many companies such as banks, realtors, and insurance companies include mandatory arbitration or mediation clauses in the contracts you sign to do business with them. These provisions require you to resolve any dispute you have with the company through one of these out-of-court dispute resolution methods. By signing a contract that includes such a mandatory clause, you give up your right to bring a lawsuit in court. This video describes the process by which lawsuits typically get underway. The most important rules that come into play at this preliminary stage concern how much time the plaintiff has after the event happens or the conflict arises to file a lawsuit, called a statute of limitations, and which court has power to hear a case, called jurisdiction. Next, plaintiffs and defendants set the stage for trial by filing pleadings, documents that assert and contest legal claims. A plaintiff's initial pleading is usually called a complaint. A complaint asserts one or more legal claims against the defendant and asks court to take some action to award money damages, for example. A defendant's initial pleading is often called an answer. An answer disputes either all or key portions of a complaint. In an answer, a defendant may also ask for legal relief against the plaintiff, money damages, for example, or even against a third party. Many years ago, pleading rules were extremely technical and rigid, designed to weed out what the law regarded as unmeritorious claims at the earliest possible stage. As a result, many lawsuits never made it past this initial pleading stage. Modern pleading rules are somewhat more relaxed. Complaints and answers determine a case's general boundaries, but usually they don't need to be long-winded or contain technical language. As a result, the weeding out function performed by pleading rules in earlier days now falls to other procedures such as summary judgment motions. See video 7. Court systems in some states even use official check the boxes and fill in the blanks pleading forms for many common kinds of cases. If such a form is available for your kind of case, you can often download it or simply obtain it from a courthouse clerk. If not, look for pleading requirements in your local court's procedural rules. Then, to find the correct language and format for your case, refer to one of the commercially published attorney form books or pleading guides available at any law library. There's much more about this in video number 23. Caution: read the rules for your local court. As you might expect, the legal system has not completely escaped its picky past. Judges still occasionally use violations of pleading rules as an excuse to get rid of cases before the cases cross the threshold of a courtroom. You can often find picky, detailed rules in sets of local rules that govern the practices and procedures in a specific court jurisdiction. For more information on finding local rules, see video 23. For instance, except when official fill-in-the-blanks forms are available, you are still likely to encounter pleading rules governing such matters as what kind of paper you must use and where to put the staples. You can usually obtain a copy of your local court rules, in particular judges' rules, if any, from the main clerk's office in your courthouse. Follow them carefully to make sure that a clerk does not reject your pleading. A good resource on procedural rules. To locate resources that can help you learn the necessary procedural rules involved in civil lawsuits, see video 23. For a quick summary, try Civil Procedure in a Nutshell by Mary K. Kane. That's K-A-N-E. For more detailed information, we recommend the following: Civil Procedure by Jack Friedenthal, Moore's Federal Practice by James W. Moore, M-O-O-R-E, Federal Procedural Forms, Lawyer's Edition, and Fundamentals of Litigation for Paralegals by Marlene Merowitz and Thomas Mauet. Do you have a good case? Before you decide to file a lawsuit, you should do at least enough research and investigation to make sure that the facts and law on your side support a legally valid claim. That bears repeating. You should do at least enough research and investigation to make sure that the facts and law on your side support a legally valid claim. For example, the fact that your adversary gave you a menacing look is not a legally valid claim unless the look was accompanied by some threatening action. Similarly, if a car lightly touched your fender but did not damage your car or hurt you in any way, you don't have a solid legal claim. But some of the disputes and injuries that occur in our daily lives do give rise to legally valid claims. For example, you may want to sue if you suffered broken bones, pain, and a damaged car due to an auto accident, or if a roofer breached a contract by using materials that caused your new roof to leak. Even if you seem to have a valid legal claim, you should assess the strength of your case before you file a lawsuit. If a lawsuit has been filed against you, you won't have the luxury of thinking about whether to go to court. However, you need to estimate the chance of a successful defense and assess the potential advantages of settling. The following considerations will help you make a reasonable assessment. Your evidence. Consider not only what happened, but what can you prove happened in court? Do you need witnesses to support your story? And if so, are the ones you have credible? Will they be available to testify when the case goes to trial? Do you have all the paper documents and electronic records that you need? If not, do you know how to get them? See video 5. Are the documents and records admissible under the rules of evidence? See videos 15 and 16. 2. Your adversary's story. These are, again, considerations that will help you make a reasonable assessment whether or not you will have a successful defense. Your adversary's story. Examine your story from your adversary's perspective. Do you know what story your adversary will present? Assuming that the stories conflict, can you tell a judge or jury why your story should be believed? Thirdly, what you must prove. Do you know what elements or material facts you have to prove, and do you have evidence to support each element? For example, in fact, that bears repeating. Do you know what elements or material facts you have to prove, and do you have evidence to support each element? For example, if you are thinking about whether to file a claim for wrongful termination of employment, do you know whether the law requires you to mitigate damages by trying to find a new job? If so, do you have evidence of your job search? To succeed as a plaintiff, you have to convince a judge or jury, usually by a preponderance of the evidence, that you have proved each element of a claim. By contrast, a defendant can succeed by preventing proof of any single element. What can you collect? Will you be able to correct a judgment if you, will you be able to collect a judgment if you win? It won't be worth your while to bring a lawsuit if your adversary has no money or assets, because you will not be able to collect any money if you win. So before you go to court, be sure to read about collecting judgments. In fact, you might want to see video number 20 and its discussion of collecting judgments before you file a lawsuit. Regardless of how much money your adversary may owe you, if your adversary is unemployed or has few, if any, collectible assets, you may need to think about whether it makes sense for you to invest time and energy on a lawsuit. Tip: damage control. If you have been sued for behavior or conditions that might result in harm to others, you might want to practice damage control by eliminating the problem as soon as you can. For example, if you are an employer who has been sued for sexual harassment based upon a supervisor's misconduct, consider how to prevent the supervisor from harassing other employees by terminating the supervisor, providing the supervisor with appropriate training, or transferring the supervisor to a different department. Proactive measures like this can limit future liability, and under Federal Rule of Evidence 407, the plaintiff cannot offer those measures into evidence to prove that you were at fault for not having taken them sooner. See video 16. Before filing a lawsuit, you should also think about all the people or businesses who might be legally responsible for the harm you have suffered. This means that you should not focus only on the driver who struck you, the doctor who mistreated you, or the building contractor who added on the room whose roof collapsed. The more parties you can legitimately name as defendants in your lawsuit, the better your chances both of achieving a favorable settlement and of collecting a judgment, should you prevail at trial. Here are a few examples to illustrate this point. 1. In an auto accident case, you plan to sue the driver of a car that struck you. If you do some investigation and find out that faulty brakes may have contributed to the accident, think about adding the brake manufacturer and the auto repair shop that recently worked on the brakes as defendants in your lawsuit. Perhaps after you name them as defendants in your lawsuit, the brake manufacturer and repair shop may be so anxious to avoid bad publicity, legal expenses, or the risk of a large adverse judgment that they will make quick settlement offers. In the case of a doctor who may have mistreated you, your inquiries may indicate that the insurance company that included the doctor in its company health plan negligently allowed the doctor to practice medicine in areas in which the doctor is not qualified. If so, you might name the insurance company as well as the doctor as defendants in the lawsuit. In the case of a building contractor who did a substandard room addition, you may learn that part of the reason for the roof's collapse is that the contractor was itself supplied with substandard roofing materials by a roofing supply company. If so, you might name both the manufacturer and the seller of the roofing materials as defendants in the lawsuit. Unless you have expertise in the subject matter of the lawsuit, you may not immediately be able to identify all individuals or businesses that could be legally responsible for the harm you have suffered. And even when you can identify additional legally responsible parties, you must balance the likelihood of collecting from them against the fact that naming additional defendants increases the scope and cost of case investigation and adds to the overall complexity of your lawsuit. Jurisdictional rules that determine which court has power to hear a case may also make it hard to include all defendants in a single lawsuit. In short, you may want to consult a legal coach before filing a lawsuit to talk about whether the possible financial benefits of adding defendants outweighs the additional time, money, and energy you will have to investigate your case. Caution: don't file a frivolous lawsuit. Investigate before you sue. To reduce the possibility that the parties you sue will claim that you filed a groundless lawsuit simply to harass them, and perhaps sue you for abuse of process or malicious prosecution, make sure that you have what Federal Rule of Civil Procedure 11 refers to as evidentiary support for the claims in your complaint. You have to do some legwork or even hire an expert in the particular field before deciding whether you are legally justified in filing the complaint. Occasionally, you may even encounter rules that require you to demonstrate that a complaint is justified. For example, in many states, if you want to sue a doctor for medical malpractice, you will have to attach your complaint to a physician's certificate attesting to the legitimacy of your claims. Is your lawsuit timely? You may have a great case, but if you wait too long to sue, the defendant can quickly get the case dismissed, that is, thrown out of court. Statutes of limitations protect defendants from being hit with stale legal claims by strictly limiting how long a plaintiff has a file to lawsuit. As a plaintiff, you have to be careful not to spend so much time negotiating with an adversary or debating whether to file a lawsuit that you miss this deadline. How much time do you have in which to file? How long do you have in which to file a lawsuit? It depends on your state's law and your legal claims. Every state has its own time limits. And even within a state, the period you have to file a lawsuit varies according to the type of claim. For example, rules in one state may allow plaintiffs with personal injury claims, for instance, a broken leg suffered in an auto accident, 1 year from the date of the injury to file a lawsuit. But those same rules give plaintiffs who sue for breach of written contract, for example, failure to make good on a promissory note, 4 years from the date of the breach to sue. In another state, personal injury plaintiffs may have 2 years to sue, and plaintiffs with breach of written contract claims may have 5 years. Tip: forget about statutes of limitations if you file suit within a year, except for when you sue a government agency. You almost always have at least 1 year from the date of harm to file a lawsuit, no matter what type of claim you have or which state you call home. So, if you sue within this 1 year period, you should be fine. For example, Henry is injured in an auto accident on February 1st. On March 1st of the same year, a lawyer whom Henry hires for a couple of hours of advice recommends that he seek compensation for his injuries from the driver of the other car. Henry spends months trying to settle with the other driver's insurance company. Finally, on September 1st of the same year, the insurance company writes to Henry and offers to settle the case for $1,000. Henry concludes that the offer is grossly inadequate and decides to sue the other driver. If Henry isn't sure of his state's statute of limitations for personal injury cases, he should be sure to file the suit by February 1st of the next year. If Henry files within a year, his lawsuit will be timely. Caution: shorter time limits apply to claims against government agencies. Often you cannot sue a government agency unless you first file an administrative claim with the city, county, or state of which the agency is part. Check your state's rules quickly after you suffer harm. You may have only 60 days to submit an administrative claim. If, as often happens, the government denies your claim, the denial letter will tell you how long you have to file a lawsuit in court. Statutes of limitations only set deadlines for filing a lawsuit, not for how long it takes for the case to conclude. However, most states do have separate diligent prosecution statutes that require you to move your case to trial within a certain amount of time, or you could face a dismissal. Defendants must alert the court to a statute of limitations violation. If you are a defendant who thinks that the plaintiff may have waited too long to sue, you'll also need to check the applicable state or federal limitations period to determine whether the lawsuit is timely. Judges rarely throw out late claims on their own. To be sure that a judge dismisses an untimely case, you will probably have to include an affirmative defense in your answer, alleging that the plaintiff's complaint is untimely. As an alternative to filing an answer, some courts allow you to file a motion to dismiss, asking the judge to throw out an untimely complaint. When does the clock start ticking? Once you've learned what statute of limitations apply to your case, your next step is to determine when the clock starts ticking. As mentioned above, in most situations, the time starts to run on the date of harm. However, there is a huge exception to this general rule to protect plaintiffs in situations where they may not be aware for months or even years that they've been harmed. In such situations, statutes of limitations may begin the clock ticking either on the date of discovery or of the harm, or the date on which the plaintiff should have discovered the harm. In short, for some types of legal action, the statute of limitations clock can start ticking at any of 3 different times. At the earliest, the date on which the harm occurred. Secondly, if not, then later, the date on which the plaintiff reasonably should have discovered the harm. This refers to the date when a judge considers it fair to say that the plaintiff should have known about the harm even if the plaintiff did not actually know about it. And finally, at the latest, the date on which the plaintiff actually discovered the harm. Here's one example. On February 1st, a doctor performs a gallbladder operation on Phoebe, but mistakenly removes Phoebe's spleen. The doctor tells Phoebe of the mistake as soon as she wakes up. Phoebe's time period for suing the doctor begins to run on February 1st because the harm occurred on that date and Phoebe actually knew it. If a 2-year statute of limitations for medical malpractice applies to Phoebe's case, she'd have 2 years from February 1st to file a lawsuit against the doctor. Example number 2. The same case above, except the doctor tells Phoebe nothing of the surgical mistake. Phoebe is in constant pain following the February 1st surgery. A month later, on March 1st, Phoebe talks to another doctor who tells her that she should not be in pain and that she should immediately come in to have it checked out. Phoebe delays going to the doctor until July 1st of the same year, at which time she finds out that her spleen had been removed, mistakenly on February 1st. In this situation, Phoebe's time period for suing the doctor probably begins to run on or shortly after March 1st, because the pain coupled with the second doctor's advice determines when Phoebe should reasonably have discovered the harm. Example 3. The same case above, except that Phoebe suffers no unusual after effects following the February 1st surgery. Phoebe is unaware that anything went wrong with the surgery until July 1st of the same year, when an X-ray during a routine medical checkup reveals that her spleen was removed. In this situation, because Phoebe did not discover and could not reasonably have discovered the harm until July 1st, most states would start counting Phoebe's time to sue on July 1st. Here's another example. After Andre was convicted of murder, the conviction was set aside by an appellate court because Andre's arrest was illegal. After the charges were dropped, Andre sued the arresting officers and the city for false arrest. Andre argued that the statute of limitations did not begin to run until the murder charges were dropped. However, because false arrest consists of detention without legal process, the statute of limitations on Andre's lawsuit began to run earlier, on the date that he was taken to court and charged with murder. If you don't know the names of all potential defendants, actually, back up. Plaintiffs who are minors, when they suffer harm, generally have longer than the usual periods within which to file suit. In general, statutes of limitations don't start running, that is, in legalese, they are told, T-O-L-L-E-D, they are told until a minor reaches 18, no matter how old the minor was when the harm occurred. For example, Mac Auley, age 12, had been the adorable child star of a hit TV show for 7 years when the show went off the air. At that time, an accountant told Mac's family that during its entire 7-year run, the show's producer had paid Mac only half of what was due under Mac's written contract. Most states would start counting Mac's time to sue from the date of his 18th birthday, and because states generally have either 4-year or 5-year statutes of limitations for disputes based on breaches of written contracts, Mac might be able to wait until he was 22 years of age to file suit, or 10 years after the date of discovery of the underpayments, and 17 years after the earliest underpayment. Of course, Mac's parents or guardians would be wise to file suit on Mac's behalf while Mac is still a minor. A stale case is generally harder to prove, and after years of delay, Mac might well be less adorable than he is now. If you don't know the names of all potential defendants, protect the statute of limitations by suing John Doe. If you think that a person or organization whose identity you don't yet know has contributed to your damages, consider naming Doe defendants, in addition to the defendant or defendants you are able to name. Doe defendants, so-called because, like John or Jane Doe, their identities are unknown, act as placeholders in the complaint. If and when you discover the actual identity of one of these anonymous troublemakers, you can amend your complaint to substitute the actual name for one of the Doe defendants. For example, assume that you are a homeowner who intends to sue Bill Jones for vandalizing and destroying expensive plants. You have information that at least 2 others participated in the vandalism, but you don't know who they are. If so, your complaint might name Bill Jones and Does 1 through 5 as defendants. The complaint should allege that Bill Jones and other persons acting in concert with him vandalized your plants. If you later find out that Mary Smith was one of the other participants, you can amend the original complaint to substitute Mary Smith for Doe number 1. The primary reason to name Doe defendants is to overcome a potential problem with the statute of limitations. For example, assume that your state's relevant statute of limitations requires you to file a vandalism lawsuit within 1 year after the vandalism incident. By the time you learn Mary Smith's identity, more than a year may have passed. If you don't name Doe defendants, and then more than a year later try to amend your complaint to add Mary as a defendant, Mary could have a complaint dismissed against her because the statute of limitations has expired. However, If you substitute Mary Smith for Doe number 1, the substitution dates back to the date when the complaint was originally filed, before the statute of limitations expired. Thus, Mary could not have the complaint dismissed as untimely. Sample statutes of limitations periods. Set forth below are California statutes of limitations for common types of legal claims. These are examples only. California's rules may change, and the rules in your jurisdiction may differ. However, the California rules are fairly typical and should give you a good idea of what you're likely to find when you read your state's rules. See video number 23 for information about how to look up state laws. For medical malpractice, 3 years from the date of injury, or if reasonable diligence was exercised, 1 year from the date of discovery of the injury, whichever occurs first. Breach of an oral contract, 2 years. Breach of a written contract, 4 years. Childhood sexual abuse, 8 years from a childhood sexual abuse victim's 18th birthday, or 3 years after the date that the childhood sexual abuse victim discovers or reasonably should have discovered that psychological injury or illness occurring after age 18 was caused by the sexual abuse, whichever comes later. For suits for libel or slander, 1 year. For personal injury claims based on negligence, 2 years. Suits for injuries resulting from domestic violence, 3 years from the last act of domestic violence or from the date a victim discovered or should have reasonably discovered injury or illness resulting from domestic violence, whichever occurs later. Now, which court has the power to hear your case? The U.S. and state constitutions, as well as federal and state laws, establish and limit courts' jurisdiction. Jurisdiction simply means the power to hear and decide a case. To make a legally valid decision, a court must have both subject matter jurisdiction, which is the power to hear the kind of case a lawsuit involves, and personal jurisdiction, which is power over the parties involved in the lawsuit. This is important because in addition to filing a case on time, a plaintiff has to file it in the proper court. If you mistakenly file a case in the wrong court, a defendant may get the case moved, perhaps to a court that's less convenient or favorable to you than if you had chosen the proper court, or even get the case dismissed altogether by filing a motion to dismiss for lack of jurisdiction. If your case is dismissed for lack of jurisdiction, you may be able to refile the lawsuit in the proper court. But if the statute of limitations runs out before you can do this, your mistake in selecting a court may mean that the defendant can have your lawsuit thrown out permanently. For almost every type of case, the rules we talked about below make it pretty simple to figure out in which court you should file your complaint. Be aware, however, that jurisdiction issues can occasionally become extremely complex when they involve such fundamental questions as whether a case should be heard in federal or state court, or whether a state has the power to require residents or businesses from a different state to appear in its courts. Honoring other court cases. Under what is known as the full faith and credit clause of the U.S. Constitution, every state has to honor cases legally decided in other states. This means that if the court in which you file a lawsuit has proper jurisdiction, meaning the legal right to decide the case, you can enforce the judgment anywhere in the country. You may have to register your judgment in another state before you can collect in that state. Federal court jurisdiction. In general, you file a case that involves state law in a state court. Again, you file a case that involves state law in a state court. Because the overwhelming majority of cases, such as those involving personal injury claims, divorce, landlord-tenant problems, consumer claims, probate matters, and contract disputes, arise under state law, it is fairly easy to separate out the few types of cases that must or can be filed in a federal trial or district court. Each state has at least one federal district court, and populous states contain as many as 4 different federal districts. You may file a case in a federal district court only if the court has what lawyers call subject matter jurisdiction. Federal courts have subject matter jurisdiction in 2 kinds of cases. Cases that arise under a federal law and diversity of citizenship cases. So cases that arise under a federal law, called federal question cases. Federal district courts have subject matter jurisdiction if your case is based on, that is, that it arises under any federal law. Examples include: 1, you sue a police officer who wrongfully arrests you under a federal civil rights statute that allows people who are arrested unlawfully to file civil lawsuits seeking damages. 2, you sue an individual under federal patent law for manufacturing an item that violates your patent. As an owner of a small business, you sue a large company for violating federal antitrust laws. Under a federal law aimed at eliminating discrimination by businesses, a civil rights organization sues a restaurant chain for policies that discourage patronage by members of an ethnic minority group. And 5thly, pursuant to a federal law called ERISA, you sue the insurance company that has denied your claim for mental health benefits. The other kind of case over which federal courts have subject matter jurisdiction is diversity of citizenship cases. Federal district courts also have subject matter jurisdiction if you are suing a citizen of a different state or a foreign national, and you are asking for at least $75,000 in money damages. This monetary floor may be responsible for the old saying, don't make a federal case out of it. Don't be fooled by the subject matter jurisdiction label. If a federal court has jurisdiction based on a diversity of citizenship, the subject matter of the case doesn't matter. Examples of federal diversity jurisdiction include: 1, as a citizen of New York injured in a traffic accident, you sue the New Jersey citizen who was driving the car that struck you for $90,000 in damages. You could file the complaint in a federal court in either New York or New Jersey. As a business person who is a citizen of Florida, you sue a citizen of Great Britain for breaching a contract and causing you to lose $100,000. 3, Bluegrass Corporation, a corporation whose headquarters are in Kentucky, sues Seedling Company, a company headquartered in Washington, for $300,000 for breach of contract based on seedlings supplying the wrong kind of grass seed. You could file the complaint in a federal court in either Kentucky or Washington. And 4thly, a company headquartered in Tennessee sues a Texas internet news service provider for $125,000 for publishing false information about the company's business operations. You could file the complaint in a federal court in either Tennessee or Texas. Little side note here. As far as citizenship, for diversity jurisdiction purposes, individuals can be a citizen of only one state at a time and are generally citizens of the state in which they maintain a principal residence. A corporation can be a citizen of 2 states, the state in which it is incorporated and the state in which it maintains its principal place of business. When corporations do business in multiple states, courts use a nerve center test to determine the principal place of business. For example, the U.S. Supreme Court ruled that Hertz Rent-A-Car's nerve center was New Jersey, because that was the state in which Hertz corporate officers directed, controlled, and coordinated the company's activities. Federal courts have diversity jurisdiction only if complete diversity exists between all of the plaintiffs and all of the defendants. That is, if every plaintiff is a citizen of a different state than every defendant. Example 1, Cobb, a Georgia citizen, wants to sue Peachy Corporation, a Delaware corporation with its principal place of business in Atlanta. Diversity jurisdiction does not exist because Cobb and Peachy are both Georgia citizens. Cobb, this is example 2, Cobb, a Georgia citizen, wants to sue Ruth, a Maryland citizen, and Wagner, a Georgia citizen. Diversity jurisdiction does not exist because Cobb and one of the defendants are citizens of the same state. Moving on to dual jurisdiction. Most lawsuits that can be filed in federal district court can be filed in state court. Federal courts have exclusive jurisdiction only in very few kinds of federal question cases, such as lawsuits involving copyright violations, patent infringement, and federal tax claims. This means that plaintiffs in all diversity jurisdiction cases and nearly all federal question cases have a choice of suing in federal or state court. Lawyers call the process of deciding which court is best for a plaintiff's case forum shopping. A plaintiff who has a choice of courts may consider such factors as 1, which courthouse is closer to the plaintiff's place of work and business. For example, a plaintiff may choose to file in a state court simply because the nearest federal court is 250 miles away. 2, which court has a longer statute of limitations? A plaintiff whose case is untimely under state law would surely choose to file suit in federal district court in a federal question case if federal law provided a longer statute of limitations. By the way, federal courts use a state's statute of limitations in diversity jurisdiction cases. Third, you might want to consider this factor. Differences in the judges. For instance, a plaintiff may think that local state court judges have a judicial philosophy that makes them more likely to sympathize with the plaintiff's claim. And then finally, differences in the jury panel. State and federal courts may have different boundaries for jury selection purposes. A plaintiff may, for example, file suit in federal court because it selects jurors from a wider geographic area. See an expert. Consult a legal coach for advice on forum shopping. Remember what forum shopping is? It's the process of deciding which court is best for a plaintiff's case. When you try to choose the court that will be most favorable for your case, many subtle factors come into play. If you have a choice of courts, it would be wise to consult with a lawyer who has experience in both federal and state courts. See Finding a Legal Coach in video number 1. State court jurisdiction. State courts almost always have the power to hear cases involving events that took place in that state. They can also hear cases in which the defendants reside in or are served with the relevant court papers, usually a summons and complaint, in that state. Unless your lawsuit is one of the few types of cases over which federal courts have exclusive jurisdiction, as mentioned before, those being cases that arise under a federal law called federal question cases, or diversity of citizenship cases. Remember, diversity has to do with citizens being citizens of different states. Unless your lawsuit is one of the few types of cases over which federal courts have exclusive jurisdiction, the state court in the state where you live will probably have jurisdiction to hear your case, whether you're seeking an adoption, guardianship, or divorce, suing a landlord, a tenant, a contractor, or a repair shop, taking someone to small claims court, probating a will, or getting involved in one of the vast variety of other kinds of legal disputes. If you're listening to this video series and are or will be involved in a lawsuit, the odds are overwhelming that you will be in a state court. Here's a couple examples. 1. Dobbs, a Michigan resident, buys a used car from Rick's Used Cars in a Michigan business. A few weeks later, the car breaks down and Dobbs learns that it needs a new engine. Dobbs sues Rick's Used Cars for fraud and breach of contract in Michigan, which has jurisdiction because Rick is a Michigan business. Example 2. Allnut lives in Arizona and is involved in a traffic accident in Arizona with Marlowe, a Texas resident. Allnut could file a lawsuit in Arizona State Court, which would have jurisdiction because the accident took place there. Every state has a motorist law that confers jurisdiction on its state courts to hear cases involving all traffic accidents occurring in that state. Allnut could also file in Texas, where Marlowe resides, because state courts almost always have jurisdiction to hear cases filed against defendants who live in that state. However, Allnut could not file the lawsuit in California or Florida in an effort to combine a vacation with legal business. Neither state is the site where the traffic accident occurred or the defendant lives. Finally, this case is an example of dual or concurrent jurisdiction, and Allnut could file in federal court if he wished. Example 3. Elaine, a New York citizen, sues Officer Kramer, also a New York citizen, for violating her civil rights by falsely arresting her. Elaine bases the suit on a federal statute, which is 42 United States Code 1983, and asks for damages of $10,000. A New York federal court has the power to hear Elaine's case. Because the case is based on, that is, it arises under, a federal statute, the New York federal court has jurisdiction even though Elaine and Officer Kramer are citizens of the same state and Elaine seeks less than $75,000. Alternatively, Elaine could file the lawsuit in New York State Court, which would have the power to hear the case because the arrest occurred in New York and both Elaine and Officer Kramer lived there. The state court has concurrent jurisdiction with the federal court and can enforce the federal law as it would a state law. Elaine can choose between federal and state courts in New York. Even after you determine that the state court in which you plan to file your lawsuit has proper subject matter jurisdiction, your search for the correct court is not finished. You must next consider the following issues. 1, whether the state has a specialized court to hear your type of case, because most states divide up their trial court's business according to the plaintiff's desired relief and the case's subject matter. And which county or city court within a state is the proper place for your case, called determining venue. These issues are discussed briefly below. State courts that specialize according to the plaintiff's desired relief. When states divide up their trial court's business according to what the plaintiff is asking for, also known as relief, they typically consider the amount of money and the type of remedy a plaintiff seeks. For example, a court may only have the power to award monetary damages up to $5,000 or may not have the power to issue a non-monetary or extraordinary remedy, such as an injunction, which is an order that the defendant do something other than pay money, like tearing down a fence that encroaches on the plaintiff's property. States use somewhat varied formulas when allocating business to trial courts according to a plaintiff's desired relief. However, the following 3 divisions are typical. Small claims courts, which hear cases involving up to a certain amount, usually between $5,000 and $10,000 in damages. Then there's courts for medium-sized claims, perhaps limited to cases involving up to $25,000, and then courts for all cases involving higher amounts or involving requests for injunctions or other non-monetary remedies. Terminology for different court divisions varies from one state to another. For example, a few states refer to their highest level trial courts as Supreme Courts, while other states refer to them as superior, district, or county courts. Check your state's court rules if you don't know which court has the power to hear your case. Tip: check your state's latest rules on courts' monetary limits. States often amend the dollar divisions between different trial courts. For example, a few states that now limit small claims courts to cases involving up to $5,000 are considering raising the amount up to $7,500 or even $10,000. State courts that specialize according to the case's subject matter. Just as many restaurants have a typical menu, just as many restaurants have a limited menu, many courts only hear certain types of cases, regardless of the dollar amount of the case or the type of relief the plaintiff seeks. Specialization by subject matter allows judges and other court personnel to build expertise and handle a certain type of case quickly. For example, a particular state may have specialized family law courts, hearing divorce, child support, and related matters, probate or surrogate courts, which is hearing guardianship cases, determining the validity of wills and trusts, and distributing the property of deceased persons, and even landlord-tenant courts. If the state has set up a specialized court to hear your type of case, that is the court to which you will be assigned regardless of how much money you seek or whether you seek a non-monetary remedy. So here's sample state trial court structures. Here are the general trial court structures for 7 states, based on the court's monetary limits. To determine the current court structure for other states, consult your state's court rules or the Directory of State and Federal Courts, Judges, and Clerks published annually by the Bureau of National Affairs. California. You have small claims court, which claims up to $7,500 for individuals and up to $5,000 for corporate plaintiffs. And then superior court, claims in any amount. In Colorado, you've got small claims court, claims up to $7,500, county court, claims up to $15,000, and district court, claims in any amount. Illinois, small claims court, which is claims up to $10,000, circuit court, claims above $2,500. In Michigan, municipal court, which is small claims court up to $3,000, other cases up to $15,000. Then district court, small claims court up to $3,000, other cases up to $25,000, and circuit court, claims above $25,000. In New York, you have town and village justice court, which is small claims court up to $3,000, city court, which is small claims court up to $5,000, other claims up to $25,000, district court, small claims court up to $3,000, and other claims up to $15,000, county court, claims up to $25,000, and Supreme Court, claims above $25,000. In Pennsylvania, Philadelphia Municipal Court, small claims court up to $10,000. District Justice Court, claims up to $8,000. And Court of Common Pleas, claims above $8,000. And then Texas, Justice of the Peace Court, small claims court up to $10,000. County Court, which is claims from $200 to $5,000. And then District Court, claims above $200. Venue. Once you've determined which type or level of state court has the power to hear your case, you must pick the proper venue. Choose which county in the state is the correct location for the lawsuit. Venue rules limit the counties in which a case can be filed in order to spare defendants the needless inconvenience of fighting a case far from where the defendant lives or from where relevant events took place. For venue purposes, the correct county may be the county where 1, the defendant resides or does business, 2, where the contract was signed, 3, the county where a contract was to be carried out. 4, where an auto accident took place. Or 5thly, other events leading to the lawsuit transpired. Because more than one county can be the correct venue for a lawsuit, often a plaintiff can compare courts, often called forum shopping, when deciding in which county to file a lawsuit. Example, George and Jerry are both citizens of Texas. George lives in North County near Oklahoma, and Jerry lives 600 miles away in South County near Mexico. One day, George drives south and Jerry drives north, and they collide in the middle of Texas, in deep in the heart of Texas County. George wants to sue Jerry. Venue rules probably require George to sue Jerry either in South County, where Jerry resides, or deep in the heart of Texas County, where the collision occurred. George's home base, North County, is not a proper venue for the lawsuit, so Jerry is spared the inconvenience of having to defend himself there. Moving to a more convenient court. The doctrine of forum non-conveniens allows a defendant to ask a court to transfer a case to a court that is more convenient to the defendant and has a greater connection to events involved in the lawsuit. For example, diversity jurisdiction rules would allow Dan, a California citizen, to sue Raquel, a Maine citizen, in California for $100,000 for a traffic accident that occurred in Maine. Almost certainly the witnesses and all the physical evidence will be in Maine. Raquel could file a motion asking the California court to exercise its forum non-conveniens discretion and transfer the case to a federal court in Maine, and the court should grant her request. Tip: venue made easy. The venue is almost always proper if you file a lawsuit in the court closest to the place in which the defendant resides or does business. If you are in doubt about venue and don't want to wade through the rules and exceptions, file the lawsuit there. And then personal jurisdiction. For a party to obtain an enforceable judgment in either a federal or state court, the court must have power over the particular defendant, that is, the individual or business you are suing. Lawyers refer to this as personal jurisdiction. Subject matter jurisdiction rules determine where a plaintiff can file a case. Personal jurisdiction rules determine whether a court has power over a particular defendant. Since jurisdiction is such an important and vital subject, I'm going to read the section again on personal jurisdiction. For a party to obtain an enforceable judgment in either a federal or state court, the court must have power over the particular defendant you are suing. Lawyers refer to this as personal jurisdiction. Subject matter jurisdiction rules determine where a plaintiff can file a case. Personal jurisdiction rules determine whether a court has power over a particular defendant. Tip: personal jurisdiction rules are usually the same in state and federal courts. With a few exceptions beyond the scope of this book, federal courts have the same personal jurisdiction as the state courts located in the same state. Federal courts do have greater jurisdiction than state courts when a defendant is not a resident of any state, but has enough contacts with the United States as a whole to justify a federal court exercising jurisdiction. See the Federal Rules of Civil Procedure 4, subsection K, subsection 2. This is a very unusual situation that you almost surely won't have to deal with. Defendant resides or does business in the state. The nearly universal rule is that the courts in a state have personal jurisdiction over all all people or businesses that are citizens of or do business in that state. For example, 1, you sue an Illinois citizen in an Illinois state court for breach of contract. It doesn't matter where you live or where the events leading up to the lawsuit took place because an Illinois state court has personal jurisdiction over all citizens of Illinois. Point 2. You sue an Illinois citizen in an Illinois federal court for breach of contract. Just like an Illinois state court, an Illinois federal court has personal jurisdiction over all citizens of Illinois. However, to establish that the Illinois federal court also has subject matter jurisdiction, you'd need to be a citizen of some state other than Illinois and ask for damages in excess of $75,000, or the case would have to arise under federal law. Other ways to get personal jurisdiction. Personal jurisdiction rules can be a bit stickier when you file the suit in a state other than the one in which the defendant is a citizen or does business. To protect a defendant from being sued in a hostile, possibly distant location, personal jurisdiction rules require that it be fair for a court to exercise power over a non-citizen based on the facts of the case. Example, Debbie is a Texas citizen vacationing in Florida. While in Florida, Debbie buys what she is told are 2 brand new, fully loaded computer systems at Kevin's computer shop. Debbie later learned that the computers are loaded with reused parts and won't perform the tasks that Kevin claimed. Debbie cannot sue Kevin in her home state of Texas. Texas has no personal jurisdiction over Kevin because Kevin doesn't reside or do business in Texas, and he hasn't been served with the court papers, usually a summons and complaint, in Texas, as described below. Nevertheless, courts can and often do have personal jurisdiction over citizens of and businesses in other states in a variety of circumstances. Here are standard situations in which courts have personal jurisdiction over non-citizens in their state. 1. The defendant enters the state in which you have filed suit after the case is filed, even if only for a short visit, and you serve the defendant with the court papers, normally a summons and complaint in the state. As in the children's game of tag, you have to find and tag the defendant with the papers while the defendant is in the state. Example, you sue Herb, an Ohio citizen, for breach of contract in a court in Minnesota where you live. After the suit is filed, your process server sees Herb drive into Minnesota for lunch and serves Herb with the summons and complaint in Minnesota. Of course, the Minnesota court would also need subject matter jurisdiction. A Minnesota state court has subject matter jurisdiction because Herb was served in Minnesota. A Minnesota federal court would have subject matter jurisdiction if you and Herb were citizens of different states and the complaint asked for more than $75,000 in damages, or if the complaint was based on federal law. Secondly, so again, here are some standard situations in which courts have personal jurisdiction over non-citizens in their state. Here's a second situation. The defendant caused a traffic accident in the state in which you've filed a lawsuit based on the traffic accident. Remember, all states have motorist statutes giving their courts power to decide cases growing out of accidents on their highways, regardless of the party's citizenship. You could serve the defendant with the lawsuit anywhere, not just in the state where the lawsuit was filed. Here is another situation in which courts have personal jurisdiction over non-citizens in their state. The defendant, whether individual or business, has engaged in at least a small but significant amount of activity that constitutes minimum contacts in the state in which you filed a lawsuit based on that activity. The minimum contacts requirement generally means that a defendant, whether it's business or person, who is a citizen of a different state must have enough connection to the state where a case has been filed for a judge to conclude that it's fair for the state to exercise power over the defendant. While it's risky to overgeneralize in these situations, a judge would probably conclude that minimum contacts exist in the following situations. A business with its headquarters in another state maintains a branch, office, store, or warehouse in the state in which the suit is filed. Or a business with its headquarters in another state sends mail order catalogs into the state in which the suit is filed. Or an individual who is a citizen of another state solicits business by making phone calls to advertisers, making phone calls to customers, or publishing advertisements in the state in which the suit is filed. And finally, an internet service provider that is a citizen of another state does business with paid subscribers or takes online orders from customers in the state in which the case is filed. Example number 1. While on vacation in Vermont, Ora, an Ohio citizen, visits Fred's Vermont Antiques and sees what is labeled as a packet of ancient Etruscan coins. Fred tells her they are rare and worth much more than the $5,000 he is asking for them. When Ora returns home to Ohio, she calls Fred and buys the coins. She then discovers the coins are actually worth only a few $100s and wants to sue Fred. If Fred neither advertises nor does business online or by telephone in Ohio, Ora will have to file the lawsuit in Vermont. Because Ora made the phone call to Fred rather than the other way around, Fred does not have enough minimum contacts with Ohio to allow an Ohio court to exercise power over him. Here's example number 2. Donna, a California resident, establishes a website on which she sells a line of Huggy Poo dolls that she designed. Michael, a New Jersey resident, sues Donna in New Jersey State Court for trademark infringement, claiming that Donna's dolls unlawfully interfere with similar Hugster dolls that he designs and sells. In the absence of specific New Jersey-related business activities, the mere existence of Donna's website is probably not enough to allow New Jersey to exercise jurisdiction over Donna. But if Donna has an office in New Jersey, owns property in New Jersey, has shipped dolls to New Jersey customers, or if advertising on her site targets New Jersey residents, New Jersey may well have jurisdiction over Donna. Jurisdiction based on real property ownership. A state has limited jurisdiction, which lawyers call in rem jurisdiction, over a non-citizen person or business that owns real property in the state. Jurisdiction in this situation is limited in 2 ways. 1, jurisdiction extends only to the fair market value of the real property. This means that if you sue a non-citizen who owns an apartment worth $500,000 in the state in which you file a lawsuit, the most your judgment can be worth is $500,000. In addition, the claim probably has to relate to the property. For example, you could get jurisdiction over the non-citizen owner of an apartment house if you slipped and fell on the property, but you could probably not get jurisdiction over the non-citizen owner if the lawsuit grows out of an entirely separate problem that has nothing to do with the apartment house. Tip: a minimum contacts claim is stronger when the claim relates to the purpose of the contacts. Assume that you want to sue an out-of-state business, Able Company, in your state. You believe the court has jurisdiction because Able maintains a bicycle warehouse in your state. If your claim relates to a bicycle that you picked up at the warehouse, a judge is likely to conclude that it's fair to exercise personal jurisdiction over Able Company and allow your suit to proceed. But if your claim against Able Company grows out of a totally separate problem that has nothing to do with bicycles, the judge may conclude that Able Company does not have enough minimum contacts and dismiss your case at Able Company's request. Moving on to beginning a lawsuit. In the beginning of a lawsuit, the parties must file several documents with the court. Plaintiff's complaint. The complaint is the document that starts a lawsuit. It sets forth the facts underlying the dispute, the legal claims, and the damages or other relief the plaintiff, which is the person bringing the lawsuit, seeks from the defendant, the person or business being sued. Rules regarding how detailed a complaint has to be vary from state to state. In recent years, U.S. Supreme Court cases have generally given federal court judges increased leeway to throw out complaints that consist of too many conclusions and not enough facts. While legal conclusions such as the defendant was careless can provide the framework of a complaint, they must be supported by factual allegations that plausibly give rise to a claim for relief. For example, someone hurt in a car accident may sue the other driver. In the complaint, the plaintiff may ask the court to order the defendant to pay monetary damages to compensate the plaintiff for bodily injuries and damage to the car from the accident. Translated into everyday language, that complaint may say something like, the defendant hit my car. He hit my car because he carelessly ran a red light, which is against the law. I suffered damages in the amount of $100,000 because of his carelessness, $10,000 for the car repairs, $50,000 for medical bills, $20,000 in wages I lost since I couldn't work because of the injuries, and $20,000 for the tremendous pain suffered. Therefore, I want the court to order the defendant to pay me $100,000. To draft or write up your complaint in the proper format, you should first determine whether your court requires you to use a court-approved form. Ask the clerk's office and read the court rules. If you don't have to use a specific court-approved form, follow the example of many lawyers and consult a legal form book in the law library. As the name implies, form books are collections of legal documents written in a fill-in-the-blanks style. See video 23 for more on legal form books. Now, here's a tip. The names may change, but pleadings are essentially the same. A complaint or initial pleading is called a petition in some courts or for some types of cases. When the term petition is used, the person suing is called the petitioner, and the person responding is called the respondent. Caution: sample forms are illustrations, not models. Throughout this video, you will find examples of legal documents that you are likely to encounter. We include these samples only to give you an idea of what the documents may look like. Because rules differ in different court systems, the actual documents used in your case may vary greatly from the samples. In video 23, we will help you to find forms that meet specific requirements in your court. Subject to local variations, complaints commonly include 1. Identifying information. Your name, address, and phone number go in the upper left-hand corner of the first page. As an option, you may also include a fax number and an email address. This information enables court personnel and the defendant to contact and mail documents to you. Secondly, a caption. A caption identifies the court in which you filed the case, the parties, such as John Doe Plaintiff versus Jane Doe Defendant, the case number issued by a court clerk at the time of filing, and sometimes the type of case. For example, a caption may mention the complaint is for breach of contract or negligence. 3. Jurisdictional facts, federal court cases. To establish a federal district court's power to hear a case, the plaintiff must include in a complaint information establishing the court's subject matter jurisdiction. See Federal Rules of Civil Procedure 8, Section A. For example, in a federal court diversity jurisdiction case, The complaint must refer to the different states of which the parties are citizens and request damages in excess of $75,000. In a federal question case, a case that arises under federal law, the complaint must refer to the federal law on which the case is based. Facts showing a federal district court's personal jurisdiction need to be specifically mentioned. It's up to the defendant to raise a challenge to personal jurisdiction if there's a potential problem. 4, jurisdictional facts. State court cases. Stating jurisdictional facts is ordinarily not necessary in state court cases. However, it's usually necessary that the complaint establish venue by identifying the county in which events giving rise to the dispute took place or in which the defendant resides or does business. 5, factual assertions. In plain English, you should briefly recite the facts or allegations that make up your legal claim. You do not have to set forth all the evidence on which you rely. A short summary of what happened is usually good enough. We will discuss legal form books in chapter 23. They have very helpful examples of allegations for common types of legal claims, such as negligence or breach of contract. Here's the tip. Don't just recite your desired result. Though your complaint doesn't have to state all the background facts involved in your claim in detail, you do have to do more than make a vague, conclusory statement such as, the defendant owes me money and I want the court to order him to give it to me. Instead, refer to the key facts giving rise to the debt. For example, if you are suing to recover money someone owes you on a written promissory note, refer to the contents of the note and attach the note as an exhibit to your complaint. Here's another tip. A few states insist on more detailed complaints. Several states, including California and New York, are what lawyers often refer to as code pleading or fact pleading states. These states require that complaints include facts that support each element of your legal claim, though you don't have to specifically refer to the elements by name or include voluminous details in the complaint. For a discussion of how to identify the elements of a legal claim, see video 8. 6, the prayer for relief. Your complaint has to tell the court what you want by way of legal relief. The term prayer means request and is a throwback to times when the church heavily influenced the courts. Most often, you'll ask only for money damages. However, you might also ask the court to order the defendant to do something, such as tear down a fence that encroaches on your property, or stop circulating a defamatory letter. In some states, the prayer may also ask a jury trial if you want one. A prayer for relief comes at the end of a complaint. 7, your signature. Normally, your last task is to follow the prayer for relief with your signature, identifying you as the person making the legal claims. In many states, you can verify your complaint by including, above the signature line or on a separate page, a verifying statement such as, I declare under penalty of perjury that the allegations in the complaint are true. Look at what your state's rules for the exact language. When you verify a complaint, you force the defendant to file a verified and more detailed answer. In some instances, such as petitions for marital dissolution or divorce, a state's law may require that your initial pleading be verified. 8, jury trial demand. This part of the complaint tells your adversary and the court that you want a jury trial. But be aware that pretrial rules in your court may also require you to file a separate jury demand document and pay jury fees to preserve your right to a jury trial. Be sure to check your state's rules. Caution. You may have to attach an exhibit to your complaint. Many states require plaintiffs to attach documents called exhibits to complaints in certain types of cases. For example, if a plaintiff's suit is based on a written contract, the plaintiff may have to attach the contract to the complaint, unless the plaintiff can explain why the contract is unavailable. Similarly, if a plaintiff sues a doctor for medical malpractice, the plaintiff may have to attach a good cause affidavit from another doctor stating that the plaintiff has a reasonable basis for filing the complaint. If exhibits are required, the complaint should state that the necessary exhibit is attached. For example, a complaint may state, a copy of the licensing agreement is attached hereto as exhibit number 1. Caution. Be scrupulously accurate when you verify a complaint. Your representation that all statements in your complaint are made under penalty of perjury will ordinarily be taken very seriously by judges. For example, if what you say under oath later in the case, perhaps in an affidavit you submit to the court during a deposition or when testifying at trial, varies from what you say in a verified complaint, your opponent may offer the contradictory complaint language into evidence to cast doubt on your credibility. This will not happen if your complaint is unverified. I think I meant to say this will not happen if your complaint is verified. You may have to complain to a governmental agency first. Lawyers and self-represented parties alike may find the legal system exhausting, but that isn't what lawyers mean when they talk about exhaustion of remedies. This legal principle is designed to save judges the trouble of having to decide cases that could be resolved in a different form through non-court procedures. Plaintiffs are often required to exhaust or take advantage of administrative complaint processes before going to court. For example, assume that a shipping company thinks that a new state trucking regulation is unfair and illegal. Before suing to overturn the regulation in court, the shipping company might have to challenge it before the state agency that drafted the regulation. Only if the agency upholds the regulation after all administrative processes have been completed can the shipping company challenge the regulation in court. Similarly, assume that a property owner seeks a variance from a zoning ordinance before a city's zoning board. If the zoning board turns down the request for a variance, the property owner may have to appeal the decision to the city's zoning appeals board before going to court. However, plaintiffs are required to exhaust remedies only if the remedies they seek are actually available. For example, a judge will require a property owner to appeal an adverse zoning decision only if the city's administrative procedures provide for an appeal process. When a judge upholds a defendant's objection to a complaint that the plaintiff failed to exhaust other remedies, the judge normally issues a stay of the complaint. As a result, the complaint is not dismissed or thrown out of court. Instead, the complaint remains on file in the court system, and the plaintiff may resume court proceedings if the non-court proceedings are unsatisfactory. This ensures that a plaintiff won't miss the statute of limitations deadline while exhausting other potential remedies, as long as the complaint was filed on time in the first place. Sample factual language necessary for some common legal claims. Though modern pleading rules allow for much flexibility, here are examples of acceptable, short summary, factual statements for common types of legal claims. For negligence, 1. On September 22nd, 2010, Plaintiff Kibo was driving westbound and Defendant Jackson was driving eastbound on Olympic Boulevard. 2. Defendant negligently made a left-hand turn to go north on Main Street, colliding with plaintiff's car. 3. As a result of defendant's negligence, plaintiff suffered loss of income and personal injuries that required hospitalization. Plaintiff will require additional medical treatment and will lose additional income in the future. Plaintiff's car was also damaged beyond repair. In the example of breach of contract, on March 12, 2012, Plaintiff Napland and Defendant Edelstein entered into a contract for certain repairs to Edelstein's house. A copy of the contract is attached to this complaint as Exhibit A. 2. Plaintiff made all the repairs called for by the contract and has fully performed all obligations required by the contract. 3. Defendant has refused to pay and continues to refuse to pay $17,000 that is due and owing under the terms of the contract. In the case of fraud, on March 31st, 2014, Plaintiff Eben and Defendant Strauss entered into a written contract in which Plaintiff agreed to purchase from Defendant a vacant lot located in Milwaukee County, Wisconsin. The price agreed upon was $125,000. A copy of the contract is attached to this complaint as Exhibit A. Under the terms of the contract, Defendant stated that the lot was suitable for building a home. 3. This representation was false and fraudulent because Defendant had used the lot for many years for dumping brewery residue, rendering the land clearly unsuitable for human habitation. Defendant knew that the representation was false and made it for the purpose of inducing Plaintiff to enter into the contract. 4th, Plaintiff relied on Defendant's representation when purchasing the lot and was damaged as a result. And then here's an example of an acceptable short summary factual statement for promissory note. On or about February 14, 2014, Plaintiff Martinez loaned Defendant Chung the sum of $10,000. Defendant signed a promissory note, a copy of which is attached as Exhibit A, agreeing to repay this amount in its entirety to Plaintiff along with interest at the rate of 10% per year on October 14, 2014. Defendant did not pay the amount due under the promissory note, and the entire amount plus interest is now due and owing to Plaintiff. More about damages and the prayer for relief. A prayer for relief doesn't necessarily have to specify an exact amount of damages. For example, in a personal injury action, the prayer for relief may simply ask for damages according to proof. Specific amounts aside, a prayer for relief may ask for compensation of various types, such as general damages, also called compensatory damages and actual damages. These are damages that are directly attributed to the defendant's wrongful act. Common examples of general damages include lost wages and medical bills. Then there's relief. A prayer for relief may ask for compensation of various types. So compensation for pain and suffering. This is a form of general damages by which defendants have to compensate those they injure for the pain and inability to carry on everyday activities that the injuries produce. Because the amount of damages for pain and suffering depends on judges' and jurors' subjective feelings, some states put caps or limits on the amount of damages for pain and suffering that they can award. Compensation can be claimed for special damages, sometimes called consequential damages, are indirect harms that flow from wrongful acts. For example, a business owner's claim for compensation for the loss of reputation caused by the defendant's wrongful act is a claim for special damages. To allow defendants to fairly assess the scope of the potential damages they may be ordered to pay, many jurisdictions require plaintiffs to specify special damages, if any, in their complaints. Other kind of compensation is punitive damages, sometimes called exemplary damages. These are a form of punishment of defendants whose actions may not have only been wrongful, but malicious and egregious. For example, a jury may order a cigarette manufacturer to pay punitive damages if it concludes the manufacturer intentionally added ingredients increasing the addictiveness of its cigarettes. Plaintiffs must be entitled to general damages before punitive damages are even a possibility. In most states, punitive damages are not even a possibility in breach of contract actions. And even if a defendant's reprehensible conduct has caused damages to thousands of people, a punitive damages award can reflect only the harm done to the parties to a specific lawsuit. And then there's a compensation that's called liquidated damages. These are the amount of damages that parties agree to in advance, typically in a written contract. For example, an employment agreement may state that if the employer fires the employee before the agreement expires, the employee's damages are limited to $50,000. Courts typically enforce liquidated damages clauses only if they were reasonable at the time they went into effect. Caution. Check your local court rules before you try to file anything. In many courts, it is customary and may be required by court rule to submit papers on pleading paper, which is just paper 8.5 by 11 with line numbers running down the left side of each page. You can get a supply of this paper at a stationery store. If you use a computer or to type your documents, check to see whether your word processing program offers it as a built-in option. Some courts impose other rules on how papers must be presented. A court may, for example, require 2 holes to be punched at the top of the page so the paper can be inserted directly into the court's file folder. Or it may require you to attach what's sometimes called a blue back, a stiff piece of blue paper to the back of your pleadings, and some courts require a cover sheet with your initial complaint. Tip: you can amend your complaint. Pleadings such as the complaint can normally be amended or changed after they are filed. For example, assume you are a pedestrian and plaintiff suing Miss Adams in the accident example just above. After you have already filed a complaint against her, you determine that the companies that manufactured the car and the brakes may also be legally liable, and you want to add these companies as defendants. Typically, if the defendant has not yet responded by filing an answer, you do not need permission from the court to amend. But you do need permission from the judge if the defendant has already answered your complaint. In that case, you will have to file another paper with the court, a request for leave, that is permission, to amend your complaint in which you state the reasons for the changes. Tip: class actions. A class action is a lawsuit filed by one or more plaintiffs on behalf of a large group of people who have a common grievance against the same defendant. Federal Rule of Civil Procedure 23 governs class actions in federal court. Class actions often arise when a common problem makes it worthwhile for people with individually small claims to join together. Class action procedures are complex, and courts can refuse to certify a case as a class action based on factual differences between the plaintiff's individual situations. If you think you have a claim that's suitable for class action, you should contact a class action specialist. And summons. After a complaint is filed with the clerk's office, along with the required filing fee, the court usually issues a paper called a summons. The purpose of a summons is to advise the defendant about the lawsuit and to provide a number of important facts about the case, including the names of the plaintiff and defendant, called the parties, the name, address, and phone number of the plaintiff's lawyer, if any, the case number assigned by the clerk's office, and the dates by which the next pleading, normally a response by the defendant, must be filed. Generally, after the summons is issued, the plaintiff arranges for the summons and complaint to be served on, physically delivered to the defendant. Rules about these and other legal documents must be served, called service of process. They must be strictly followed. If they are not, sometimes the lawsuit cannot go forward. Service of process is governed by Federal Rule of Civil Procedure 4 in federal courts. In state courts, you can usually find local service rules in your state statutes, usually in the volumes on civil procedure. See video number 23 for more information on finding legal rules and reference books. Here are some rules about service of process that apply in many court systems. 1. Normally, as a party to the lawsuit, you may not personally serve your own complaint and summons if you are the plaintiff, or your own answer if you are the defendant. You also cannot serve your own motions, that is, requests for a court order, or subpoenas, court orders compelling someone to come to court. Another person must serve these pleadings for you. In some states, legal documents must be served by a law enforcement officer, sheriff, marshal, or constable, or a licensed private process server. But in many other states, any adult not connected with the lawsuit can serve legal papers. 2. A complaint must be served on the defendant within a certain time after it is filed. For example, a complaint and summons must be served within 120 days after filing in federal courts. This is Federal Rules of Civil Procedure 4, Section M, and within 60 days under certain state rules. 3. To serve legal documents on a business, for example, when your adversary is a company rather than an individual, you usually don't have to serve them personally. In most cases, it's enough to have the document delivered to the business and have a copy of the document mailed to the same address. If the business is a corporation, you must serve the designated agent for service of process. You can find out who this is by checking with your state's Department of Corporations. 4th, some courts don't require personal delivery at all in certain circumstances. They allow service by regular U.S. mail. Fifthly, courts require proof of service, usually in the form of a signed document that states when, how, and on whom the complaint and summons were served. Often you must file a proof of service whenever you file any type of pleading with the court under Federal Rules of Civil Procedure 4, subsection 1. There's usually a deadline for filing. For example, a proof of service must be filed within 90 days of filing the complaint in some court systems. Tip: you can be reimbursed for filing fees. The filing fee that the plaintiff pays when the complaint is filed with the clerk's office is considered one of the fees and costs of suit. That means that if the plaintiff wins the lawsuit, the court may order the defendant to reimburse the plaintiff for the filing fee. U.S. courts typically do not, however, order the losing party to pay the winner's attorney fees. Defendant's response. A properly served defendant must respond to a complaint within a short period of time, typically 30 days. Under Federal Rule of Civil Procedure 12A, the defendant in a federal lawsuit has to serve an answer within 21 days after the complaint and summons is served. If a defendant fails to respond in time, the plaintiff can apply for what is known as a default judgment. A default judgment is a court order granting a judgment against the defendant to pay the amount requested in the complaint based on the defendant's failure to answer or defend against the lawsuit after having been given proper notice. In some courts, the plaintiff simply requires a request for default judgment with the clerk's office. In other courts, the plaintiff must appear in court to show the judge that the threshold requirements for a valid claim have been met. This is sometimes called a prove-up hearing. Once a default judgment is entered, filed, and written into the official court records, it has the status of any other judgment. It is as if the plaintiff had conducted and won a full trial. A defendant may, however, move very quickly to have it set aside, undone, and taken off the record. Some judges will set aside a default judgment only if the defendant was not served properly or if the defendant's failure to answer the complaint or show up in court is excusable. For instance, if the defendant was in the hospital at the time that the papers were served, or the defendant's attorney neglected to respond on behalf of the defendant, the judge might set aside a default judgment. Other judges are more lenient towards defendants and will set aside a default more readily. For reference, default judgments in federal courts are governed by Federal Rules of Civil Procedure 55 and reasons for setting them aside by Federal Rules of Civil Procedure 60, subsection B. Assuming that as a defendant you are unwilling to let the plaintiff win by default, you generally have to respond to a plaintiff's complaint in writing within 20 to 30 days after you were served. This summons accompanying the complaint will specify exactly how much time you have. If you need additional time, for example, you are just about to leave town for 2 weeks, contact the person whose name and phone number are in the upper left-hand corner of the complaint, usually an attorney, and ask for additional time to respond. Confirm an extension of time and respond with a letter. Caution: confirming extensions with the court. If your adversary agrees to extend your time to respond, you may still have to file a short notice with the court confirming that the time for response has been extended. Check your local court rules or ask the court clerk to see whether your state imposes this requirement. If the opposing party does not agree to extend time for response, you can go to court with a motion for extension of time to respond. If you don't have time to do that, file any kind of answer that contests the complaint to prevent the plaintiff from entering a default judgment against you before you can file a more complete response. You can always amend your answer later when you have more time. Caution: don't file a frivolous response. Like plaintiffs, defendants can be subject to monetary penalties if they make false claims or factual claims that are not supported by any evidence. You can respond to the plaintiff's complaint in 2 ways. 1, answer on the merits. This more common method of response typically requires filing a pleading known as an answer, which challenges a complaint's factual accuracy, makes claims against the plaintiff, and even brings new parties into the lawsuit. It may also assert affirmative defenses. Another way you can respond to a plaintiff's complaint is to raise technical defects. Typically, this means filing a legal document called a motion. Motions focus on procedural issues instead of a complaint's factual accuracy. For example, if you are not a citizen of the state in which you are sued, you may have a basis for filing a motion challenging a court's personal jurisdiction. You've always heard of winning on a technicality. This may be your chance. If the judge dismisses your technical objection and upholds the complaint, you can still file an answer challenging the merits. Let's look briefly at each type of response. Answer on the merits. A defendant's answer somewhat resembles a plaintiff's complaint. Like a complaint, your answer will include 1, identifying information in the upper left-hand corner of the first page. 2, a caption, which of course will say answer instead of complaint. 3, factual assertions, denying the claims the plaintiffs made in the complaint. The simplest way to do this is through a general denial, which states that defendant denies each and every allegation of the complaint. Assuming that you are eligible to file a general denial, it's fine to do this even if you recognize that some of the plaintiff's allegations are accurate. A general denial simply lets everyone know that the defendant will force the plaintiff to prove the claims. In some cases, you are not eligible to make a general denial. Either local court rules, get a copy pronto from the courthouse clerk's office, or the fact that the complaint is verified, which means signed under penalty of perjury, may prevent you from making a general denial. In this situation, you will be required to respond separately to each numbered paragraph of the plaintiff's complaint. In doing so, it will probably be necessary to concede the accuracy of certain allegations while denying others. For example, assume that you are sued for negligence and that paragraph 3 of the complaint states that you negligently made a left right-hand turn while driving on Olympic Boulevard and struck the plaintiff's car. Your answer may state that, quote, I admit that I was driving eastbound on Olympic Boulevard on June 3rd, but I deny each and every other allegation of paragraph 3 of the complaint, unquote. If you do not know whether an allegation in a complaint is true, you may deny based on a lack of knowledge or information sufficient to form a belief about the truth of an allegation. This is in Federal Rules of Civil Procedure, Section 8, subsection B. For example, if a verified complaint alleges in paragraph 6 that the plaintiff suffered a broken leg and you have no way of knowing whether this is really true, your answer may state that, quote, defendant has no information or belief regarding the allegation of paragraph 6, and based on such a lack of information and belief, denies the allegation in paragraph 6. Caution. How to avoid the negative pregnant. Back in the days when pleading rules were incredibly picky, the negative pregnant became one of the legal system's most colorful traps for an unwary defendant. A negative pregnant consisted of a defendant's denial that a sum of money is owed, phrased in such a way that a judge treats it as an admission that some other sum of money is owed. For example, if an answer stated that defendant denies owing $50,000, a judge can interpret this as a negative pregnant in which the defendant admits owing $49,999. Fortunately, the negative pregnant has been largely consigned to the scrap heap of legal history. However, to protect yourself against a judge who decides to make an example of you, play it safe and state that you deny owing $50,000 or any other sum. Fourth, the fourth thing to be included, a prayer for relief, which typically requests that the plaintiff take nothing and that the court award court costs to you. If your answer includes claims against the plaintiff called a counterclaim or third party called a cross complaint or a cross claim, the prayer for relief will also ask for money damages in a specified amount or according to proof, just like the prayer for relief in a complaint. And then your signature, which follows the prayer for relief. It is the complaint. If the complaint is verified, you'll probably be required to verify your answer. This means that you'll have to include a statement such as, I declare under penalty of perjury that the allegations in the answer are true, immediately above your signature or on a separate page. Check your state's law or legal form book for the wording required in your state. In addition to denying all or some of a complaint's allegations, your answer may also include affirmative defenses, counterclaims, and cross complaints. Let's briefly look at each of these. Affirmative defenses. Affirmative defenses consist of new factual allegations that under legal rules defeat all or a portion of a plaintiff's claim. As the defendant, you have the obligation to raise any affirmative defense on which you hope to rely, and at trial you'll have the burden of proving their truth. Common affirmative defenses are listed in Federal Rules of Civil Procedure, Section 8, Part C. They include, 1, the statute of limitations, an allegation that the plaintiff failed to file the complaint within the time required by law. Tip. If the court lacks jurisdiction over you, say it here. Normally, your answer will not dispute the court's power to hear the case, which is jurisdiction, because the plaintiff probably filed a lawsuit in the proper court. In the unusual case in which the court's power to hear the case is an issue, you may include that as an affirmative defense, or in the alternative, file a pre-answer motion raising lack of jurisdiction as a technical defect. So here's another common affirmative defense. In a negligence case, the plaintiff's own carelessness, often called contributory negligence, was the cause of all or some of the plaintiff's injuries. Or the plaintiff assumed the risk of injury by voluntarily engaging in a dangerous activity, such as a rock climbing, playing in a football match, or walking next to a building where thousands of pigeons roosted. In a contract action, a particular oral contract is invalid because by law, called the statute of frauds, the agreement was required to be in writing or at least referred to in a document to be enforceable. Or the defendant was a minor at the time the contract was made, or the contract was a product of duress because the plaintiff threatened the defendant with physical harm if the defendant refused to sign the contract. Accord and satisfaction, meaning that you and the plaintiff have already settled the dispute. Caution. Be sure that your answer states all possible affirmative defenses. If you do not include an affirmative defense in an answer or get a judge's permission to add an affirmative defense later, you will not be able to offer evidence to support an affirmative defense at trial. A legal coach can help you determine whether any affirmative defenses are available to you. Some states have pre-printed checkbox forms that you can use. You can find them at a law library. Let's take a look at counterclaims. Counterclaims, governed in federal courts by Federal Rules of Civil Procedure, Section 13, counterclaims are a way for a defendant to make claims against and seek money damages or other legal relief from a plaintiff. A counterclaim is particularly appropriate if you planned to sue the plaintiff before plaintiff won the race to the courthouse door and sued you first. A counterclaim allows you to use an answer not only to deny a plaintiff's allegations, but also to go on the offensive against the plaintiff. A counterclaim says, in effect, the plaintiff says, I owe money to him? No way. It's the plaintiff who broke the contract and as a result owes me the money I lost. A defendant who wants a judgment against a plaintiff has to include a counterclaim in an answer rather than filing a separate lawsuit. If the defendant's claim is based on the same series of events as the plaintiff's, lawyers call these compulsory counterclaims. I repeat, a defendant who wants a judgment against a plaintiff has to include a counterclaim in an answer if the defendant's claim is based on the same series of events as the plaintiff's. If a defendant has a compulsory counterclaim but does not include it in the answer, the defendant won't be allowed to bring that claim later. Example, you've been sued for negligence. The plaintiff's complaint states that you carelessly made a left-hand turn and collided with the plaintiff's oncoming car. Your complaint may set forth a counterclaim in which you allege that it was the plaintiff who carelessly drove into the road from a driveway after you had begun to turn, colliding with you and causing you to suffer personal injuries that required hospitalization, continuing medical treatments, lost future income, and severe damage to your car. If you don't include this counterclaim in your answer, you'll give up the right to seek damages from the plaintiff caused by the accident. Again, legal form books discussed in video number 23 set forth sample counterclaims for different kinds of cases. Cross complaints or cross claims. More rarely, you may also want to use your answer to bring a new party into the case by including a cross complaint in your answer. See the Federal Rules of Civil Procedure, Section 13, subsection G. A cross complaint, in essence, blames a new third party for any harm the plaintiff suffered. For example, if you are a defendant in an auto accident case, you may include a cross complaint against the company that repaired the brakes on your car, claiming that the improper brake repair and not your carelessness caused your brakes to fail and your car to collide with the plaintiff's. Raise technical defects. Before filing an answer, or sometimes as part of an answer, you might respond to a complaint by filing a motion to dismiss. claiming that the case cannot proceed because the plaintiff has violated one or more procedural requirements. See the Federal Rules of Civil Procedure 12. A judge may dismiss a case for serious procedural violations, and if the statute of limitations expires before the plaintiff can refile it, the procedural error may spell the end of the lawsuit. More likely, your valid procedural objections will disrupt the case by forcing the plaintiff to start over with a new complaint or even in a new court. If nothing else, the ensuing fuss and delay may convince the plaintiff that winning the case won't be easy and lead to an offer to settle. Common technical defects you can raise include: 1, the court lacks power to hear the case, that is, jurisdiction, either over the defendant personally or over the subject matter of the case. For example, perhaps the plaintiff has filed the case in federal court even though the claim does not arise under federal law, and the plaintiff and defendant are citizens of the same state. 2, here's another common technical defect you can raise: improper service of the summons and complaint. For example, instead of handing you the papers personally, the plaintiff's process server simply discarded them but claimed to have served you. Another technical defect you can raise is the complaint is vague and ambiguous. This response is not usually successful because modern pleading rules allow each side to postpone providing the details of the case until disclosure and discovery. See video 5. However, if a complaint is so vague that you are not sure of what you are supposed to have done wrong, you can make a motion for a more definite statement which, if successful, can force the plaintiff to prepare and serve a more factually detailed complaint. And finally, 4, this technical defect is called the complaint fails to state a claim for relief. Essentially, this response asserts that even if everything the plaintiff alleges is true, there is no valid legal claim. For instance, a complaint would not state a valid claim if it alleged that I bought a stock recommended by my stockbroker and it just went down in value. Just because your stockbroker recommended a stock that lost value does not give you legal grounds on which to sue the broker. By contrast, the claim might have been valid if it alleged that the stockbroker recommended a stock without disclosing that it was a speculative stock, and you had previously told the stockbroker that you wanted only conservative investments. This might be grounds for a lawsuit. Finally, resource. American Jurisprudence Pleading and Practice Forms Annotated is a comprehensive multi-volume guide with numerous forms and examples. Basics of Legal Document Preparation by Robert Cummins contains numerous examples of state and federal pleadings. And Plain Language Pleadings by Carol Ann Wilson is an attorney assistance guide to preparing pleadings. So that's it for today. Longer video, but boy, we did cover a lot with getting the lawsuit started. And boy, it's been a great illuminating time. We've shared together. We've covered whether the case is a good case, if it's timely, what kind of courts have the power to hear your case. We've discovered personal jurisdiction, subject matter jurisdiction. We've covered beginning the lawsuit with the plaintiff's complaint, the summons, and the defendant's response. And we've discussed counterclaims, affirmative defenses, raising technical defects, all sorts of good stuff. So we hope that you found this video useful. In our next video, number 4, we will be discussing pretrial procedures. And covered in that video, we will cover how, following pretrial deadlines, pretrial conferences. We'll be discussing court-ordered mediation and arbitration, initial pretrial procedures, setting the ground rules, immediate pretrial procedures, discovery and motions, and then final pretrial procedures, trial preparation, including preparing a joint pretrial memorandum, handling other pretrial documents, attending a final pretrial conference, obtaining a pretrial order, and attending mandatory settlement conference. So we'll be visiting you in that next video. And once again, just want to thank you for spending time to educate yourself and learning more about law. We try to make this as fun and easy as possible because we believe that everybody was born to be a lawyer, to have a basic conceptual grasp of the law. And we hope these videos will go a long way towards helping people feel confident in navigating these legal waters. So once again, thank you so much for spending time here. I wish you many blessings on your journey, and we'll see you in the next video.